am attorney Maricris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, we shall aim to simplify the law. We shall explain concepts and principles of law in under 10 minutes. Hi everyone! In this video, I will talk about one of the obligations of the partners, and that is to contribute to the partnership whatever that he has promised, be it money, property, or industry. So, you entered into a partnership with one of your friends. Your friend promised to contribute 500,000 to the business, and you agreed to create that partnership. What happens now if he does not give you the 500,000 that he has promised to contribute to the partnership? That friend of yours who promised to contribute 500,000 to your partnership and has now failed to contribute that money that he promised now becomes a debtor of the partnership. Why do I say that he becomes a debtor of the partnership? Because the law says so. That is Article 1786 of your Civil Code. Article 1786 says, every partner is a debtor of the partnership for whatever he may have promised to contribute thereto. What does that mean? That means that because he is a debtor now of the partnership or the other partners can now legally compel him to contribute that amount of money that he promised to contribute to the partnership. In fact, that partner of yours may even be liable for damages for his delay in contributing the property or the money in this case that he promised. Is there a need for a demand for him to be considered in delay? The answer is no. As a general rule, for one to be liable for damages for delay, the delay must be a legal delay, meaning there must be a demand that must be made first. In fact, I have already discussed the difference between legal delay and ordinary delay. I will put that link down below so that you will know the difference of such. So going back to that partner of yours who has not contributed what he has promised. From the moment of the creation of the partnership, there already arose an obligation on his part to deliver, such that there is no need for you to demand from him to deliver the money, that 500,000 that he promised. So he now becomes rather a debtor of the partnership, and because of such delay, he may even be liable for damages. Not only is your friend liable for damages, he is even liable to pay interest. That is actually Article 1788 of your Civil Code. And it says, a partner who has undertaken to contribute a sum of money and fails to do so becomes a debtor for the interest and damages from the time he should have complied with his obligation. And so if he promised to contribute money, the 500,000, our example, and he promised to contribute it on a certain day, and he failed rather to contribute such amount of money to the partnership, he becomes a debtor to the partnership, and apart from that, as I've mentioned, he is liable for damages, plus he is liable for interest. And as I have mentioned, there is no need for a demand for him to be liable for damages. Now you might ask, how much will the interest be? The interest rate that will be used for the payment of interest shall be that which was agreed upon by the parties. Now, what if you did not agree on the interest rate? Then you follow the legal interest of 12% per annum. So you, as the aggrieved partner, you can now file an action against this friend of yours who failed to contribute that which he has promised. You can file an action against him for performance, meaning that he contributed to the partnership that which he has promised. Now, what if he promised to contribute a particular parcel of land and also he did not deliver that particular parcel of land to the partnership? What is your remedy? The same thing. Your remedy now is an action for specific performance. You are now legally compelling your friend, your partner, to contribute that which he has promised to the partnership. Now, how about he promised to deliver a particular parcel of land for the business, and he does deliver that parcel of land. However, a few years into the partnership business, the particular parcel of land was adjudged to belong to another person and not your partner who contributed that parcel of land. You were unaware that that parcel of land that was contributed was actually a subject of a litigation, and now your partner lost that litigation and lost that property. It is now adjudicated or adjudged to another person. So now the partnership is deprived of that property. What happens now? Your Article 1785 of your Civil Code also has the answer to that. The second paragraph says, he shall also be bound for warranty in case of eviction with regard to specific and determinate things which he may have contributed to the partnership in the same cases and in the same manner as the vendor is bound with respect to the vendee. In other words, when a partner, in our example, your friend, your partner, contributed this particular parcel of land, he has warranted against eviction. And what is the warranty against eviction? It simply means that that partner of yours is warranted that supposedly you will not be evicted from that property, that that property really belongs to him, and that whatever he contributed to the partnership will enjoy that property that he contributed. But because he failed in that warranty, because somebody else is now the owner of that property, your civil code tells you that he will be liable for that warranty against eviction. Which brings us now to another article in your civil code on warranty against eviction. And you find that actually in sales. That is Article 1555 on the law on sales, still under your civil code. And it enumerates the liability of a seller to a buyer in case he fails in his warranty against eviction. To put simply, if a partner contributes a particular or determinate thing, just like in our example, a particular parcel of land, and he fails in his warranty against eviction, just like in our example, because now somebody else is the owner of that property, he is liable. And he is now liable to replace that property contributed, and he is also liable for the fruits that the partnership could have enjoyed due to the untimely eviction of the partnership from the enjoyment of the property. In simple terms, he is also liable for damages to the partnership. How about if your friend, the partner in your business, instead of promising to contribute money or property to the partnership, he instead promised to contribute his services, his skills. But when the partnership now was already starting the business, he did not contribute any skill. He did not contribute any service. Can you compel him to perform the service that he has promised to contribute to the partnership? Just the same way that you could compel him to contribute the money or the property that he has promised to contribute to the partnership? This time, the answer is no. Why can you not compel him to perform the service that he has promised to contribute? Just like in property or in money that he promised to contribute. The reason is your constitution prohibits involuntary servitude, such that if you force him, if you compel him to render service and it is against his will, that is already a violation against involuntary servitude. So if he will not render the service that he promised to the partnership, can you ask another person to take his place? The answer is no. Why? Because you may have other partners and those other partners may not trust the replacement. Again, we go back to the basic principle in partnership, that it is based on trust and confidence. What does this all mean? This means that if you decide to become a partner in a partnership and you have already told your partners what property or the amount of money or the industry that you are promising to contribute to the partnership, you must make sure that you do contribute them. Because if you don't, if you fail to fulfill that promise, then there will be legal consequences. The other partners may file a suit against you and you will be made liable for damages. That's it for this video. I hope you have learned something about the obligation of a partner in a partnership. If you have learned anything from this video, please feel free to click like and subscribe. If there is any other principle or concept of law which you would want me to discuss in this channel, please put them in the comments section below. Thank you for watching. See you next time in MDL Classroom.